judgment in the appeals, Allison against Her Majesty's Advocate and McInnes against Her Majesty's Advocate.
In the case of Allison, the judgment will be delivered by Lord Rodger.
On 9 September 2004, the appellant was convicted after trial in the High Court at Glasgow of 4 contraventions of Section 4.3b of the Misuse of Drugs Act 1971. The appellant appealed against his conviction. The appeal court refused his appeal. One of his grounds of appeal related to the record of a police interview of a John Stronach who had died before the trial. The Crown introduced the interview into evidence during the trial. Neither before nor during the trial did the Crown disclose to the defence that Mr. Stronach had a number of previous convictions and outstanding charges. This prompted the appellant to argue that the Crown's failure to disclose resulted in the appellant not receiving a fair trial as guaranteed by Article 6.1 of the European Convention on Human Rights. When dismissing the appellant's appeal, the appeal court held that Article 6.1 did not impose any obligation on the Crown to disclose outstanding charges against a witness. Having considered the circumstances of the case, the court was not persuaded that the Crown's failure to disclose Mr. Stronach's previous convictions had resulted in an unfair trial and hence a miscarriage of justice. The Supreme Court unanimously dismisses the appeal. At the hearing of the appeal, the Crown accepted that it had been under a duty to disclose the outstanding charges against Mr. Stronach and that its failure to do so had been incompatible with the appellant's Article 6.1 Convention rights. The only live issue, therefore, was the actual significance in the whole circumstances of the case of this failure by the Crown. Having considered the circumstances of the case against the appellant, the Court is satisfied that there is no real possibility that the jury would have come to a different verdict on the charges against the appellant if they had been made aware not only of Mr. Stronach's previous convictions, but of the outstanding charges against him as well. There has therefore been no miscarriage of justice.
I shall give the judgment in the other case. The appellant, Paul McInnes, was convicted in the High Court of Justiciary at Glasgow of assault and attempted murder. He was sentenced to 8 years' imprisonment. The crucial issue at the trial was the identification of the persons who participated in the assault. The prosecution evidence included the statement of a witness who described how he saw the appellant attack the victim. He had attended 2 identification parades at which he failed to identify the appellant. At the end of each parade, he made statements to the police, which the Crown did not disclose to the defence. The appellant contends that if these statements had been disclosed, it would have enabled his defence to attack the reliability of the witness at the trial more effectively, that this could have affected the outcome of the case, and that he was denied a fair trial contrary to Article 6 of the European Convention on Human Rights. This raises a devolution issue under the Scotland Act 1998, which the Supreme Court has jurisdiction to determine. The appellant argued that the High Court erred in applying the wrong legal test. He contends that rather than examining whether the non-disclosure caused a real risk of prejudice, the appeal court should simply have asked whether the disclosure could have made a difference to the outcome of the trial. The law on disclosure is reasonably well settled. The prosecution must disclose any material which might materially weaken its case or materially strengthen the case for the defence. Accordingly, all police statements as a class must be disclosed, and it is plain that there was a failure in the duty of disclosure in this case. The Supreme Court holds that the test for the determination of the appeal is whether, taking account of all the circumstances of the trial, the jury might reasonably have come to a different verdict if the information had been disclosed to the defence. The application of that test to the particular facts of the case is a matter within the exclusive jurisdiction of the High Court. It does not form part of the questions which are subject to review by this Court, but it is clear from the judgment of the High Court that it did apply the correct legal test. Accordingly, the Supreme Court has unanimously concluded that the appeal must be dismissed. The Court will now adjourn.